First, before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instruction, and that she made it voluntarily, freely, and rationally. So that's the answer to that question. So for the third question, does convicting guilty on a subcharge, example offense 2 number 5, convict the overall charge? So with that, what I'm going to do is I have amended the verdict slip. It's the exact same verdict slip, and it's still consistent with the jury instructions I gave you, but it's a little bit easier for you to follow. And for purposes of going through this, we'll go through it together, and I've got a copy for each one of you, okay? All right, so you'll see it really is the same verdict slip, but we've added a little bit of language to help you follow it through. So the first charge, manslaughter while operating a motor vehicle under the influence of liquor. So first, in the above entitled case, we say the defendant is, 1, not guilty of the offense charged or any lesser included offense. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Now, then you go on to guilty of the offense of as charged, manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following: manslaughter while operating a motor vehicle under the influence of liquor, and or manslaughter while operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. That means on each one, when you stop and sign the verdict slip, that means you have a verdict on this indictment. So stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence of liquor, then continue below to the lesser included offense. And first, under 3 is involuntary manslaughter. If you find the defendant guilty of the lesser included offense of involuntary manslaughter, stop and sign the verdict slip. If you find her not guilty of involuntary manslaughter, then continue to the next page. Guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence. And you have to check one or both of the following: motor vehicle homicide under the influence of liquor, and or motor vehicle homicide by operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of the lesser included offense of motor vehicle homicide, felony OUI liquor, and negligence, stop and sign the verdict slip. If you find her not guilty of motor vehicle homicide under the influence of liquor, then continue below to the guilty of the lesser included offense operating under the influence. And you check one or both of the following: operating a motor vehicle under the influence of liquor, and or operating a motor vehicle with a blood alcohol level of 0.08 or greater. If you find the defendant guilty of operating a motor vehicle under the influence of liquor, then stop. If you find the defendant guilty, you stop and you sign the verdict slip. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. And remember, your decision must be unanimous. All right, does that make it any clearer, hopefully? All right, so with that, I am going to send you back out.
Before the jurors are set up, can we see?
Sure, why don't you come on over? I don't know what I said. I heard myself read the guilty of the lesser included offense. So if you find her not guilty of motor vehicle homicide under the influence of liquor, then you continue to decide whether the Commonwealth has proven to you beyond a reasonable doubt that she's guilty of operating under the influence of liquor. And if they have not, and if you find the defendant not guilty on this offense and all other offenses, then you go back and check the first box. So you follow it from the top to the bottom in this manner. Okay? Thank you very much. We're going to release you.
All right, to the court, please. Jurors, follow me.
Jim, can I have that question, please? Thank you. All right. So as counsel knows, we received a question from the jurors. If we find not guilty on 2 charges but can't agree on 1 charge, is it a hung jury on all 3 charges or just 1 charge? I got some input from the defense at sidebar, essentially saying if we could just ignore it. We can't ignore it. To me, it's a theoretical question, and we don't answer theoretical questions. I tell the jurors that they're not to be concerned with the consequences of their verdict, and that's exactly what they're doing here. So I would propose just writing simply, this is not a question I can answer on this, and sending it back.
The defense position is not, certainly not for it. I agree, we can't ignore your question. However, I think that it is apropos, given the timing of when that question came in, literally before the court had answered the other 3 note card questions. I think that it would be appropriate to send a quick note just asking them, given the fact that there's some clarity in your other questions, does this answer your question? In other words, can you proceed without any further input by the court regarding that second question?
So that made sense initially, but why ask them, do I really need to answer it, to then tell them I'm not answering it?
Because I think at some point, they need to know what the law is. It's a reporting question. In other words, I don't see it as theoretical, as the court indicated. I see it a little bit differently, which is what are our options? And the options are built in the law, not in theory. If they come back with a verdict on more than 1 count, but they're hung on a separate count, they are to report those 2 counts, whatever counts they came to a verdict on.
So that's for a later time, right? So this is at this point.
Right.
It's premature, it's hypothetical, it's theoretical. I understand your point. I think I disagree with you at this point. It may be something later. The way the question's worded, if I find this, if we do this. I'll hear from the Commonwealth.
We agree it's consequence related. Your first suggestion, I think, is most appropriate, and we would endorse that.
Yeah. I'm going to do that at this time, Mr. Jackson. I'm not going to have a back and forth with them. I'm simply going to say, because it's true, it's the law, that this is not a question I can answer.
But I would strongly suggest that we find some other way. If that question continues to remain, then they're not going to ask that question. I don't think the court can say, or should say, I can't answer the question, because the court can answer that question. The court absolutely can answer it. I would simply say this question is not before the court without further information, or something like that. Not the court can't answer that question, because if that question remains in their minds, we're going to end up in the exact same position that we were in last year.
There are other steps that can be taken to perhaps prevent that.
Whatever
do you say?
those steps are, I think the first step down the wrong path is to say, throw our hands up and say, well, we can't answer that question. Well, we know we can answer it.
So I don't know if I want to put you in an uncomfortable position, Ms. Giannetti. I'm inclined to answer the question the way I stated.
Could we have 2 minutes to confer with counsel, Your Honor?
How about 1 minute? You guys are 10 minutes late.
We just need 1 minute.
Thank you.
Just with a very slight tweak with the court's language, I don't have a principled objection to the court's language that we not answer the question at this time. I would simply ask that the court answer the question as you suggested just now in open court. It's premature to address this question at this time.
No. What do you say, Mr. Brennan? My response was, this is not a question I can answer for the reasons I stated. It's theoretical, and we tell jurors that they cannot be concerned with the consequences of their verdict, and that's exactly what you would be asking me to endorse. What's the Commonwealth's position on the proposed?
I agree with your first suggestion.
Yeah. I'm going to send it in like this. Your objection's noted.
Your Honor, if I could make my record a little bit clearer, the court's indicating that it doesn't answer questions about the consequences of the juror's verdict. That would be punishment. Of course you can't answer a question like that. This is not the consequences of the verdict. It's how do they report a verdict. So I think saying, I can't answer this is sending a false message to the jury. If the court would simply indicate, this is not appropriate for me to address at this time, that assuages all concerns. Certainly assuages our concerns, and it protects Ms. Reed's rights. I think that
Well, I think what I could add is this is a theoretical question, not a question I can answer. That does the same thing. Is there an objection? I understand, Mr. Jackson.
If the court could add the clause at this time.
Is there an objection to me putting this is a theoretical question, not a question I can answer?
No objection.
I allow the court to finish writing, but at this point, that is over our objection.
I understand.
I just want to make sure the record is absolutely clear. That's over our objection. I don't think that's an appropriate answer to a very, very clear question that could be answered in an innocuous way that does not affect Ms. Reed's rights. I
Okay.
think this way it does.
Okay, it was a clear question that the defense first told me to ignore. So,
I didn't tell
that.
you to ignore anything, Your Honor.
all right, we are all set. So let's send this in, please.
All rise. Court is back in session. You may be seated.
All right, jurors, I know you want to go home, so it's been a long day for everybody. I have to give you those same cautions. Please do not discuss this case with anyone. Do not do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Be careful with your social media use. We know you've all been working really hard and we appreciate it. So please just clear your heads. Don't think about this case at all as best you can. And we'll see you tomorrow morning when everybody's fresh to start again. Thank you.
All rise to the court, please. There is following. Jury's exited the courtroom.
Okay, Tori. All right, we'll see everybody tomorrow.
Thank you.
Court is adjourned.